What about OSHA? Your requirements to enforce OSHA is going to depend on your location. It's difficult to enforce on short duration projects. It's hard to get all of those things in place if the project's only going to last 3 to 6 months. It's an excellent source of information for you. Take a look at the OSHA website, and it walks you through quite a few requirements and suggestions for how to enforce safety on site. And it might be the hammer you're looking for. OSHA 200 log versus the OSHA 300 log. Take a look at your contract, see what might be required depending on where you are and when you're working on your project. OSHA guidelines for the contractor that the CM should be aware of. These requirements take management, commitment, and employee involvement. It means that labor and management have to be involved in the accountability for meeting the OSHA requirements. Every job site requires a job site analysis, and that's to look at job-specific hazards or risks that could cause an incident or an accident. Also, OSHA gives a set of guidelines for how to handle an incident or accident investigation, and you may be required to comment, to be involved in that accident or incident investigation, and you should certainly comply with the requirements that they have. Hazardous prevention and control. OSHA has a whole set of guidelines for how the contractor should do that, and I would recommend that you go online on the OSHA website and take a look at those, see what they are, so you can discuss it with the contractor in a knowledgeable manner. Safety and health training for the construction workers on site. This should be held typically by the general contractor as toolbox training. It may go down to the subcontractors, their superintendents and foremen, providing toolbox training on a weekly basis for their workers, just reminding them of those typical things, not using frayed electrical cords, wearing their PPE, etc. And it does require employee involvement and a periodic plan evaluation. That's where the CM can actually have some input, is to go back with the general contractor, review their plan, make sure it's kept up to date, and advise the owner if you feel like it's not adequate. OSHA provides data for the incident rate for construction projects. National averages from BLS are 7.1 for recordable injuries and 3.2 for lost time injuries. This is based on 100 workers calculated using this formula: number of accidents divided by number of hours worked and multiplied by 200,000, or simply N over EH times 200,000. EH is the number of hours worked. The top 10 OSHA standards violations cited for 2003. You could take a look at this chart and see the types of incidents that are most often required or cited in violations. I'd like to point out a couple of these that have been very severe in the last couple of years, which have been crane accidents. You may have heard about one that happened in New York where a crane collapsed and damaged not only a building but the street below and a number of vehicles. And they've had a couple of incidents like that in Texas as well. So for real large construction, high-rise, etc., you want to be careful, make sure that you have crane operators, crane inspectors taking a look at those before the cranes are put into operation and during operation, to make sure that the maintenance is checked every day and that your operators are operating those cranes properly and with the proper safety precautions. The top 10 OSHA standards violations cited for 2005. Just a different year here, but you'll see that some of the same items are listed. Safety and training and education. These are things that should be included in your construction contractors' weekly or daily operations. They should have toolbox training, weekly safety meetings, etc. on site. Another one that's very typical is fall protection or lack of fall protection, that they're tying off themselves, their tools, any loose material that they may be working on a scaffold where it could fall and injure either themselves or another party. OSHA requirements and third-party liability. OSHA requirements are always there to help protect the owner and the workers from any type of safety incident, and you can't ignore your contract when you have substantial supervision over the construction. Third-party liability. The laws surrounding third-party liability are going to differ from state to state, so find out about the state in which your project is located. You will or may be sued if there's a major incident on site. You want to fall back to your contract and review it to see what your actual liability is. The contract and employee actions will most likely determine your company's fate. In that case, as I've said, when you observe a safety violation, you want to make sure that you bring it to the owner's and the contractor's attention in writing as soon as you possibly can. Multiple employers and the safety plan for the site. The workplace policy. Citations are normally issued to the employer of the exposed employees or exposing employer. The citation possibly is issued to the employer who has contractual responsibility or authority for safety, the controlling employer. That would generally be the general contractor. A citation is possibly issued to the employer who created the hazard. So if the drywall contractor is injured by an action of the electrical subcontractor, it may be the electrical subcontractor who is cited. And a citation may possibly be issued to the employer who has responsibility for correcting the hazard. Hopefully it's the same person who created it, so that you don't have one person correcting the actions of another. That can cause a lot of legal problems too. Two recent cases, both involving excavation accidents. The first one is in Pennsylvania, where the CM was found not to be liable. Superior Court of Pennsylvania refused to impose a legal duty on the firm premised solely on the engineer's presence at the time of the accident and his actual knowledge of a dangerous condition created by a contractor's failure to follow proper safety procedures. However, in Kansas City, they were held liable. An inspector had actual knowledge that the trench was unsafe. The inspector was directed not to interfere with the contractor's operations or means and methods, and the Supreme Court ruled against, in this case, the AE firm. So bring it to someone's attention. Don't be bullied or talked into, oh, we do it this way all the time. No. Bring it to the owner's attention, bring it to the contractor's attention in writing so that they know, if you were aware, that you made note of it and ask for them to correct the hazard. This will protect your company from being found liable for an incident.